Joining me now, NBC's Garrett Haake, NBC investigations correspondent Tom Winter, and former U.S. Attorney Joyce Vance. So, Tom Winter, first to you. Take us through all of what we learned from the producers inside the courtroom and an adjacent overflow room, including whether Trump can review those materials alone.
Right. So, Andrea, this was a hearing that typically we wouldn't even report on. We might just attend and send a note in later. But given the public interest in this case involving the former president and given the issues here and how much of a megaphone Donald Trump has, this hearing took extra importance today. And it's basically all about what evidence that is going to be shared from federal prosecutors during the scope of their investigation with the defense, what evidence can be shared or can perhaps be made public out of that leading up to the trial date. And a protective order is not uncommon in criminal cases, but here there was a pretty wide gulf between the two sides with federal prosecutors saying, look, everything's protected, nothing can be disclosed. That's what they were arguing for. And the defense was saying, well, wait a minute, we should be able to disclose some things. We're going to have to interview people. We're going to have to talk to people about what they said. And so perhaps you can make it more about certain sensitive documents that might pertain to certain witnesses, personal identifying information, things like that. And the judge made an oral ruling and should docket later today the specifics of what she has in mind. But basically, from our producer, Daniel Barnes, in the courtroom, the judge says, look, there'll be certain sensitive things that the defense, including Donald Trump, cannot disclose under any circumstances. But there'll be other things that can be asked about, talked about, and presumably, perhaps, if the defense wants or Trump wants, to be made public prior to trial. To your specific question there, Andrea, the idea of what Donald Trump can review, prosecutors said that he should not be allowed to review evidence alone, that he should not be allowed to take notes or take documents by himself, even kind of winking and nodding towards the Florida case, saying he has a habit of taking documents that he shouldn't take. And so that review by the former president, he'll have to have some restrictions on how he reviews evidence, and that's something that he might have to do with his attorneys as well. Again, more details will come out in the judge's order. What will start to happen here once this all gets hammered out, Andrea, is 11.6 million pages of documents will be handed over from the special counsel's office to Donald Trump's defense attorneys, including, according to our notes, extraction from devices, which is a fancy way of saying images from cell phones. So basically, it appears at this point that they're either cell phones or computers, laptops, et cetera, that federal prosecutors and investigators have gotten their hands on in the course of this investigation, and they image those devices, and this is not a perfect term for it, but try to make the best copy possible. It's better than just copying the device and handing it over to the defense. That's something that happens in every case where that type of investigative work has been done. So a lot of information coming to the former president's attorneys and to the former president. We'll get all the specifics laid out a little bit later today. That's the plan, at least. That's what the judge said in court. And then from there, we go to the trial. One other potential issue here, the judge happened, and we just got this quote. The judge said, even arguably ambiguous statements by the parties or their counsel, if they could be reasonably interpreted to intimidate witnesses or to prejudice potential jurors, can threaten the process. And the judge noted that the more those statements are made, the faster they will go to trial. So clearly the judge letting the defense know, and the defendant, the former president of the United States, exactly where she stands on the issue. Andrea?
Wow, that's all I can say. You know, Joyce Vance, let's talk about this. First of all, there was a quick agreement on a protective order. For all the fuss about a protective order, there was a quick agreement in Florida on both sides in the classified documents case, and I believe one also in Manhattan. So the fact that this was such a big deal early on from the defense side seems extraordinary and possibly for delay. Joyce, as a former prosecutor, what is your take?
So I think you're dead on the money. These are routine. There was always going to be a protective order imposed in this case. The question was just how long Trump's lawyers could drag it out for. And you know, Judge Chutkan, who today admonished the parties against permitting a carnival-like atmosphere to take over this case, understands what's going on here. She's issued a very moderate ruling. She gave the Trump camp some of what they wanted. Only sensitive documents fall within the ambit of the protective order. But by the same token, sensitive documents will include anything that the government received from agencies other than DOJ. That includes anything that they received from January 6 hearing materials. So there's a win here for both sides, but mostly an end to Trump's efforts to delay this process.
And just a quick question: what about grand jury testimony that's from witnesses, but not from other agencies? Is that sensitive, or does that have to be decided on a case-by-case basis at sidebar, let's say, with the judge?
No, the grand jury material will all fall within the protective order. It can be used at trial. It becomes public then. But at this point, that will remain confidential. And Judge Chutkan is very clear about this. You know, if there is something arguably wrong that happens that could, for instance, prejudice the future jury or could impact the safety of witnesses, she said in no certain terms today that she will hold the Trump team accountable, even if something ambiguous takes place.
And Garrett, what do you think is happening behind the scenes with Donald Trump being told that he can't take his phone or any devices in when he's reading these materials, and that the lawyers have to be outside?
Well, look, something like a no phones while you're in the room rule that might actually be enforced. But I think there's pretty wide recognition between Trump's inner circle and the wider circle of people who support him that the idea that he's going to follow a protective order about talking about this case broadly, the way the judge described it, anything that could be reasonably interpreted as, you know, malicious or as meant to influence this case, there's 0% chance that Donald Trump is going to avoid anything that could be reasonably interpreted as trying to influence this case. He and his allies firmly believe this is only political. They have certainly cast this case as entirely political, and they're going to continue to make political arguments about it. This order will launch 1,000 segments on cable television talking about which thing Donald Trump said today could be reasonably interpreted to break the judge's order. This judge will be tested on this point. And how is she going to enforce it? That's an excellent question. I mean, typically, enforcement on something like this, you could be held in contempt, you could be fined, you could be locked up. Good luck. Out on bail. She says, you know, she's going to treat this like any other case. She's not taking political considerations in mind here. But I think, again, in the practical world, that's going to be very difficult to enforce. And Joyce Vance, just quickly, do you have any take on how well she can enforce it, given the political climate?
So I think what we'll see Judge Chutkan do on the first offense is bring Donald Trump into her courtroom. She'll admonish him that future violations will result in more serious action. You know, the big question here is whether she'll actually revoke his bond and put him in custody pending trial. She knows what she's about. She has a background both as a defense lawyer. She's a very good judge, straight up the middle on the law. If you treat Trump like anyone else, that means if he violates the protective order, he does lose his right to remain on bond pending trial.
Garrett Haake, Tom Winter, and Joyce Vance, thanks for starting us off.